Hello and good afternoon to one and all present here. I am Madhur Rathod, the founder and director of LexPeeps.in and acting as a moderator for this event. I welcome you all in the LexPeeps exclusive workshop on Moot Court Challenges How to Overcome. I would like to thank my guests from the core of my heart for accepting the invitation. Before moving further, I would like to take this opportunity to introduce LexPeeps.in to all of you. LexPeeps.in, established in 2019 with a vision to expand horizons of legal fraternity. At LexPeeps.in, we are a dedicated platform for law students where we provide internship opportunities to the law students and with other facilities like the moot court events, debates, etc. It's my utmost pleasure to let you know that now we are providing research internship to nearby 40 students per month, and we have more than 1K followers on Instagram and thousands of unique visitors per day on each page of our website. We have received an overwhelming response of over 500 students for this event. It's just in 2 days of the time when we started registration. I would like to introduce you all with our respected panelists today. We have Advocate Jayant Bhatt, advocate at Delhi High Court and Supreme Court, acting as Standing Counsel Central Government in Delhi High Court. Mr. Bhatt is an independent litigator based in New Delhi, India. He holds dual Masters of Law from New York University, USA, and National University of Singapore. Mr. Bhatt is a member of International Bar Association, beside being a member of Supreme Court Bar Association and Delhi High Court Bar Association. Up next, we have Mr. Alok Vajpeyi. Mr. Alok Vajpeyi is an associate working with disputes team at Singhania and Company, Mumbai. His core practice area are commercial arbitrations, litigation under Indian arbitration, etc. He has also given his valuable advice on Foreign Exchange Management Act. He is also qualified tribunals secretary certified by Hong Kong International Arbitration Center. Talking about his college experience, he is an alumni of Institute of Law, Nearby University. Up next, we have Ms. Garima Prakash. Ms. Garima Prakash is right now serving as consultant at EY. Ms. Garima has previously worked as trade law and policy analyst at World Trade Organization and as an associate at Lakshmi Kumaran and Sridharan. Ms. Garima has pursued her master's from University of Barcelona and she is an alumni of RML NLU Lucknow. Today we have as the student speaker Ms. Palak Agarwal. She is the student of NLU Odisha and has won various moot court competitions and best memorials and oralist in international moots. I would be putting some questions to first of all Mr. Jayant Bhatt, sir. So the first thing is, what is the essence of mooting, and what was the thing that motivated you to moot in your time?
Madhur, I think for me it was more like I really got bored of studies after 2 years into law school, and it occurred to me back then that it's always good to travel and start mooting and learn something new, because normal curriculum will run its course, and I still had 3 more years to go in law school. It was a 5-year law course. And once I think the thought struck my mind, I started doing, I remember, at least 2 moots every semester, which calculated to about 4 moots a year. And my understanding with my director back then was, look, I'll win you something, and please give me attendance. I don't want to bunk all my classes, but I'll get you marks. But I don't want my attendance to be deducted, and I should be held to ransom that I should not be allowed to sit in the exams. And he was very kind enough. He gave me the permission. He's like, okay, you go ahead. So as luck would have it, that was the start of my mooting journey, and I did not disappoint my law school or my director in terms of either winning or getting some prize or the other in the moots that the team participated or where we went mooting. So I think for me it was a personal journey of exploring the other facets of law, exploring other parts of the country, trying from national international moots. So I think that was a kickstart back in I think 2004 when I started mooting.
Thank you, so. And what are your views, Alok? So,
I think my views on this question is primarily, since the question is divided into two parts, what's the essence of mooting and what motivated me to moot. I'll say that generally, as a law student during my time, mostly all the seniors said that mooting is the most important thing for a law student. It still remains the same. So my primary motivation was, of course, from the side of I've heard from seniors and the fact that it is the most glamorous thing in a law school. So if you are good at moots, then all the juniors would know you. So I think that was my primary motivation. After doing few moots, uh, I feel the essence of mooting lies in the fact it helps you improving your oral and written presentation, which is very important when you join the profession, be it whatever uh, practice area you do, whatever different subject area you practice, the oral presentation and written presentation both form core part of any lawyer. So I think that mooting really taught me a lot about it. Then I think it also improved my research skill, which is another important attribute. Uh, and one less attribute, as in one less talked about attribute, that is networking opportunities. So it also gave me the chance to interact with a lot of international students, a lot of international arbitrators, judges, uh, and to know people and make connections which would be helpful throughout my life. And I think this profession is about more about networking. It's not, it's less emphasized upon, but yes, networking is very important, and I think mooting helps you in that. That's all I have to say. Thank you, Mother.
Mother, you're muted.
and what are your views, Garima ma'am, on this?
So for me, I would say that introduction to moot court competitions has really, essentially, that is what has really shaped my future career even till date. Um, I'm an international trade lawyer, and my first exposure to this subject was, in fact, through a moot court competition that I did in my second year of law school. So even though it was already my third moot into law school, and I mean, I totally agree with what Alok said that it was the thing to be doing when in law school. All the seniors that you would hear about, they were all into mooting, and we were sort of made to believe, or I mean, I wouldn't say believe, made to believe, but it was to quite an extent true also that mooting was an important aspect in law school, and I mean, it's fun, it improves your skills and everything. So in my second year, I chose to do the Gandhinagar International Moot Court Competition, which was on WTO law, and that's what introduced me to WTO law. And since then, I've really pursued that as my career. So for me, mooting was, of course, it started as a co-curricular activity that I was doing as a extra thing on top of my academics. But then it really, I took I mean, I took advantage of that in order to get exposed to explore the different subjects of law and finally really understand what my interest lies in and to pursue it further. That's all.
And what made you, thank you, ma'am. And what made you to choose Moots, Palak?
Uh, First of all, am I audible now? What motivated me to participate in moot court competitions was that, as Alok sir and Jayant sir already said, that since it was um always talked about in law school, so I started it at that note. However, when I read and when I got to know more about the law, I understood the intricacies and nuances, and that is where I started developing an interest in it. And with respect to your question, what is the essence of mooting? I would say that the essence of mooting is that you at least get to know the law. Winning or losing is another topic altogether. But the fact that you're able to understand a particular area of law to a certain depth is what is, I believe, the essence of mooting.
Thank you, Palak. My next question to the panel will be that how someone should choose that he should go for mooting or debating in law school, or he should choose something else.
Um, I'd just take it just to address it very briefly that I don't think there necessarily has to be a choice between mooting and debating. And I mean, me or a lot of my other classmates from law school, all of us were debating and mooting at the same time. And I think both of these activities uh, help in development of the basic skill of oral presentation, like Alok said, and that is something extremely essential for a lawyer. So while I mean, although the difference between mooting and debating is essentially the time required to prepare, I would say, uh, I think one should definitely venture into both. Ultimately, if they want to continue doing it, they want to do it more, they want to do it less, is up to them based on how interested they are. But I think everyone should, I would highly encourage all law students to participate in both activities at least once. That's all.
Thank you. Thank you, ma'am.
Hi, Madhur. Just to answer your question, I was never a debater, uh, either in school or in law school, because to my mind, I have witnessed few debates, but personally, and it's only a personal viewpoint, that I think debates are very boring. I think they're very monologuish. A person keeps speaking, and I think sometimes so much that they, like the sound of their own voice, so they keep going, and then the other party come and try to thrash them down. I think that's what eventually turns out in debating by and large, outshining the other person. But I think mooting, I think there are few advantages that I realized when I was in college or law school. One, it's a teamwork. You have a team of 2 to 3 people. You're working in tandem, so that bonding is always there. Second, when you participate, it gives you a glimpse into bits and bobs of how courts will operate. Not just that, I think it's also a dialogue between the bench and the bar. In a way, to put it, you're engaging in a dialogue. You're putting your thoughts out there, and if the other person can really interject you and put a question to you, put you out of momentum, what actually also happens in courts by and large. So as opposed to debating, I mean, I know a lot of people do take part in parliamentary debates and other regular debates, but I think moot courts are very very participative. You have an audience sitting right behind you, and judges are there, and if you're trying to outsmart them, then they will pin you down. So I think that it has its own charm, and I think the various rounds that you see. Not the debating doesn't have its own rounds, but I think mooting I think is a level higher, I would say, because not only do you have to supplement your own arguments, you have to make sure that your team member doesn't suffer. Or in the alternative, if your team member is suffering as a co-speaker, or if the research is not up to the mark, then you have to ensure that you take the beating for them by giving the right answers, and at least try to cover up so that you don't lose on points. Whereas I think in debating, it's more like a solo affair. It's something, simply put, it's like being a bachelor or being married. So, I would just say that.
That's a nice way you express it, sir. So, what are your views, Alok, sir, on this?
I think I will partially agree with both Garima and Jayant. Uh, I think I'll agree with Garima to an extent that one should do both to just see how what suits them. So there would be people who would like debating, there would be people who would like mooting. So it's better you do them and then decide what suits you better. Now, coming to which of the two is better for a law student or for a legal professional, to that extent, if there is a clear debate between debating and mooting, I would agree with Jayant sir that in terms of improving your skill, in terms of improving your way you analyze things, improving your way you do your spontaneous thinking, because there would be a lot of questions you have to face while doing a moot round. So it improves your spontaneous thinking. It also allows you to anticipate the possible arguments of the opposite party. And that's what actually happens in real life. So I would say uh, mooting is more closely related to the profession. Debating might add a skill to improving your oratory skills, but I think mooting is more closely related to the profession, and also the choice as to whether one should do mooting or debating would also depend upon the time he or she has. So let's say you have only 15 days or 1 month to do something. So it's better you go for a moot rather than go for a debate rather than a moot, because mooting requires a lot of preparation and it requires a lot of, you have to invest a lot of time. So I think that's what I have to say. Thank you, Mother.
Thank you, sir. Thank you very much. The next question to the panel will be that what should be the team formation for mooting? Like team formation plays an important role. What are the points that should be considered while formation of the team?
Okay, I'll take this question. Then whatever is left, the other panelists can add. So team formation is one of the very important step of any moot before going any moot, because the first step is you look for a team. S- so the general doubts which any law student would have, that whether you form a team with a friend or with a person who you don't know at all, whether you form a team with a person who is very hardworking or with a person who has very good analytical brain. Third, it could be whether you should choose a person who is a fluent speaker or you should choose a person who's a hardcore researcher. And of course, there would be other confusions which would be there amongst the law students. I'll say one thing, it depends on person to person. I have seen so much diverse experiences and in terms of team formation. So some people are okay forming team with their friends and they have achieved a lot, but some people have failed in doing that and they prefer forming team with some professional, as in people who they don't know. So I think it depends upon what's your particular choice. However, I say one thing always: if you have a choice between a fluent speaker and a person who is a very hardcore researcher, and you see that he carries the potential of speaking fine, you should choose him, because in moods at least you are required to know the content well, and the fluency would automatically come if you know the content well. So if that is the choice between a fluent speaker and a hardcore researcher, I would go with a hardcore researcher. And always see people. You should choose uh, your team members should be passionate towards mooting and should be able to give time to the moot. So I think these are the key factors I have to say. Thank you, Mother.
Thank you, sir.
Um,
Gents,
I would like to add to this. that firstly, there are a lot of people who get confused between whether to form a team with people who are less compatible, but due to their higher ranks, a higher tier moot could be allotted, and whether to get a low tier moot with somebody you're compatible with. So, with respect to this dilemma, I would really suggest to make a team with somebody that you're compatible with, because at the end of the day, winning a low tier moot will be more valuable than only participating in a high tier moot and not learning anything from it. And secondly, the subject area of the mode that you're interested in, for example, if you're interested in arbitration, so it is better to team up with somebody who is also interested in arbitration, or is at least willing to go to that extra mile for the mode, so that there is no interest issue at the end of the through the course of the mode. That's all I have to say.
Thank you for your answer.
For me, answering this question is very simple. I think the only thing for me that used to matter was trustworthy. So if whoever I have to believe that I can trust the people I'm forming the team with. I don't want to have issues like, I don't trust if they're putting in the effort required, if they are as interested in the moot as I am, because ultimately it's the team effort that is going to matter. So in fact, I was very lucky, I would say, during my law school, because I stuck to the same team throughout 5 years, the team that I started with in my first year. So I think that way, and so I mean, when we started, we were, yes, somewhat friends, and by the end of it, all of us were really good friends. So uh, I think trust is what really matters, because everyone will have their own different styles of working. So as long as you can trust that, yes, my teammate is putting in the effort required, the dedication, they have the dedication required, I think it all goes well. That's all.
Ma'am.
Thank you.
Jayant
I
sir,
think just
kindly
to
conclude on this.
add to what Alok ji and Garima ji and Palak madam have already said. When I was in law school, my criteria, I've always based my things on instinct and destiny. So like most things in my life, first I would think which mood to choose, not out of its prestige or liking, but which college was hosting it and which part of the country or otherwise it was held. Because I would like to travel to that part if I haven't traveled before. So I would like, okay, this mood, where is it being hosted? And kitna time lagega? Is it train travel? Is it air travel? Is it road travel? So I would decide all those things more like in a backpack manner. Okay, that will get done. So first you get the thing out of the chart. Yaar, yahan jana hai. We have to reach a particular place or this college, and we have heard that they have nice food or they have bad food. So accordingly we'll decide. So things you have to keep it a little light. But once you have decided on the mood, in my time, we were quite lucky in those 5 years of law school from 2 to 7 when I was there. The idea was I think I only appeared in one intramoot at college where I think almost 80 people had signed up. And it was a campus law center DU moot. It was based on criminal law. It was my first moot. And, the team which got selected was out of, selection and on based of ranking. So top 3 people who got selected, they're still my friends for life. And when the team selected, I mooted with another friend of mine through other moots also throughout my law school career thereafter. But I also had chances, of having to go with other friends. But in my time, intra-moot only happened once. Otherwise, you had the freedom to decide your moot beforehand when the problem was out. And I think there was a sort of understanding amongst the batch and the seniors and the juniors that, look, if you're doing this moot, nobody else will come and intervene. Because there were plenty of moods going out. If let's say one team was going for Jessup, the other could go for Stetson, the other could go for Manfred, so on and so forth. So and not everybody is interested in mooting. To be honest, there are people to whom law school is a burden. They don't want to moot. There are some people who only live for the joy of mooting because they think there is nothing greater than being in the moot court circuit. So I think that really helps. And if you have your team, by and large, if they are your batchmates, it helps. But if they're also from the senior and the junior batches, there's a different sort of camaraderie you develop with them. So I think it's great fun. But as Garimaji rightly said, trust is an issue. That is paramount. If you know a person to be hardworking, if you know somebody to be sincere, your teammate not to flip out on you when the memos are to be submitted, The time is the clock is ticking, and the deadlines are coming. And also when you're arguing your matter, either you are going as a researcher or as a speaker, if you don't have the support from the other team member, if within the team there is politics, somebody is trying to put you down, then the experience and the mood will both suffer. So I think that is something that you have to keep in mind.
Thank you, sir. Sir, a question is coming for the panel from the audience. That is, does Moot has any significant impact when anyone views the CV of the student?
I think so. I mean, look, as an employer, I can tell you that if I see that somebody has done mooting, it gives me an additional point to at least talk to them about their mooting experience, and where all they have done mooting and what all did they learn, even if they have not done internship. I mean, something to talk about. Like for example, when I was a student, I've done all these things. I've written papers, I've done internship, I've done moots, etc. But it gives you that a common ground to chit chat in an interview, to see what their experience was, because experience may differ, but what the essence of mooting is. When you're a mooter, how do you feel with the the joys of winning and the sorrow of losing, I would say. So you can relate to them at a particular level. But is it the only thing that an employer has in mind? I don't think so. Sometimes people just do moot, to maybe get, like I said, I used to, my point was to travel, but some people do it to travel, to have fun, to get certificate, and not take it seriously. So at the same time, as an employer, not only are you gauging somebody's seriousness, you are also seeing whether, as a mooter, did they respect the process? Because a mooting requires a lot of hard work and research and preparation. So if you have been a lackadaisical mooter, and if you're not taken things seriously, it would also help me as an employer to eliminate you as a candidate. Just to put things in perspective.
Thank you, sir.
Just
Anything you
to
would like to add?
yeah, just to add on to it, what Mr. Jayant said, from the law firm perspective, you see, mostly in law firms, you have to work in teams. So when you are sitting in an interview in front of a law firm recruiter, your mooting experience would value to an extent, because they'll see that if you have performed well in mooting, it shows that you are good in teamwork. So that's an additional. So let's say there is a candidate who has no mooting experience and you have a lot of mooting experience, it would be an addition for sure. Uh, that's the thing I wanted to add.
Thank you, sir. Garima ma'am, what are your views on this? Garima ma'am, you're not audible.
Yeah, I could. I don't know. For some reason, I couldn't unmute. I mean, I can speak now. Um, so for that question, what I think it definitely adds value. I would not say that you do moots, you don't do, it doesn't matter. No, it definitely adds value, but it's not the be all and end all of your CV. I mean, although I very strongly believe that what really recruiters, I think from my perspective, what really recruiters look for is whether a person has really used their time in law school productively. Just attending classes, according to me, is not enough. Just scoring marks in exams even is not enough. One should definitely be engaged in these other activities. It could be mooting, it could be debating, it could be writing research papers, it could even be being associated with the cultural committee, or anything. The idea is to showcase that you are a productive person in general. You like to use your time productively. You are not one of those who will just sit idly and let the time pass away. So on a broader perspective, yes, it definitely adds value. And more specifically, I think already Mr. Jayant and Alok addressed it. So that's all from my side.
Thank you. Thank you, ma'am. Uh, the next question for the panel is we have seen the moot problems that sometimes is based on a core area of the law, like core specific subject, and sometimes some take it as maritime law or air and space law. What are the ideal things that a mooter should think before choosing the moot problem, that what suits him better and for which moot problem he should go ahead?
So I would take that question to mean that how do we choose between different moot court competitions? Because essentially, I don't think we can choose a problem. I mean, we choose the competition, and I think choosing the competition goes beyond just the moot court problem. Like I think Mr. Jayant already said that it involves factors like who is organizing it, where will you have to go for it, is it feasible for you, all those practical aspects. And then of course one of the aspects is the subject of the moot court competition, and definitely I think the most obvious thing to say will be that the law, it should be something of your interest, or either it should be something of your interest, or if you don't know what your interest is at that point, then something you want to explore. um, yeah, I think that's it.
Thank you, ma'am.
Just to add what Garima ji has said, I think in my, the area of subject has to appeal to you. So you said if let's say I think at least the 5 6 years has shown a tremendous trend to an upward trend of students toward arbitration. So a lot of arbitration moot inclination has gone up. This was always popular even in my time. It's so today, and there are also other international trade treaties moots and investment moots and arbitration moots which have come up. So I think it's also a matter of which current popular topic is in demand. So intellectual property moots used to be quite in vogue at my time. I never participated in any of them, but I'm just saying today arbitration moots are quite in vogue. But even in my time and even today, I think international moots are always very popular. So because all the big moots that you name of, whether it's ELSA or JESUPS or Manfred, or Manfred is space and aviation. Then there was a common law moot that I did. So they have different problems, but international law proposition always comes to the fore. But because at that point in time when you're in third or fourth year and you're planning to do masters, so you think, okay, let me do some international moots. It will have some good names. So you are reading Oppenheim and Brownlee and all those authors back then. I remember. So I think by that time I did around I think 4 international moots, and I was certain in my head I would never make it my career because I was so bored of reading the same thing time and again. I'm like every time I'm arguing almost the same thing, same judgment, same proposition. It's so boring, sometimes. So I thought maybe in hindsight I should have done more national moots, with a different flavor to it. Either it be environment or criminal or hit and run, whatever civil litigation. Because unless you're wanting to make a career in trade laws or international law, wanting to join a UN organization later, it makes sense. I think at least in my cycle, I think it was enough for me. And then personally speaking, I have a very fragile concentration, and doing 4 international moves, I think it was, as the saying goes, the last straw which broke the camel's back. So I'm like, I've had enough of international movement. I think if I was to relive my law school life all over again, I would say do a mix and match. Don't skip international law move. These are interesting. You have best of the teams participating in them. Do them, but also do national moves. Do as many topics as possible. Keep the variety coming in, and I think that will keep the interest going on in any mood that you participate.
Thank you, sir.
Uh, so, in my opinion, I think most of the things are covered by Garima and Jayant saw. But I think it's a I have seen people doing modes because they are winnable, and I have seen people doing modes because the experience or because the name would be good. As Palak mentioned before, that you should do a mode which is winnable. I don't really think that's though my personal opinion. Uh, Look, you go to a moot where your university has already won couple of times, right? And you return and maybe you are disqualified from semi-final, not disqualified, but you are only able to make till semis, right? Now, first of all, there would not be much appreciation you will receive from the college because of the fact that college has already won couple of times. Now, imagine a situation where you have reached semi-final in a mood where your college was never able to break in, right? In that scenario, you would have tremendous appreciation from the college. And leave about making it a mark or not. I see doing, as rightly mentioned by Mr. Jain Saw, doing tier one moves or doing international moves are of equal importance because it gives you a lot of perspective. It improves your experience. So it's not only about winning. It's never about winning a moot. It's about the journey. It's about the experience. So one thing, whenever I chose any moot, I saw the past performance of my college, so that whatever position I am in, at least I get the appreciation if I make something out of it. Second thing is, as rightly mentioned, is what law you know, what law you like, what subject area you want to explore. This is an important element. Initial in your first, second, third year, you can keep it very generic. However, once you move to your senior years and you choose to do moots, then you should make it more specific, like you mentioned, maritime arbitration or international trade law or something of that sort of. Also, quality of judges and quality of competition is very, very important that one should see. Some moods are said to be biased, that some people allege them that these are biased moods and some of the that sort of thing. So one should also focus on which moods are very transparent in terms of judging, in terms of quality of judging. So that's another thing. One final point which I think is of significance while choosing mood. One thing you should remember is how much practical relevance that law would have in your professional life. Now, for example, until look, that's my strictly my personal opinion. Uh, in my college, there was a limitation of doing one moot per calendar year, right? Now, if you have so much limitation, so you either do you one should do a moot which suits the practical life. Now, maybe relating to arbitration, commercial contract, or some taxation, and not something which is out of the blue, like Manfred Lacks is air and space law. Now, until unless you want to practice air and space law, or Jessups is public international law. Of course, Jessup is one of the most, it is the most celebrated move. So you would be tilted towards doing that move. However, I'm of the opinion that one should do a move which has more of practical significance. So if you're doing arbitration and you know in and out about that particular mood problem, it would help you in your real life also there, because there are a lot of opportunities which are there relating to arbitration. So that's my take on that question. Thank you.
Thank you, sir. So the next question for the panel is, how should an ideal memorial should be drafted? How an ideal memorial should look like, and what are the points that it should constitute in itself?
Should I answer this? Hello.
Yes, sir, you are audible.
Right. Madhur, I think first you have to stick to the rules of the moot and the proposition which is there. See, what is the page limit or the word limit they have set. I think the topmost point for any memorial is research. The research has to be spot on. Pull out as many relevant judgments as possible. Uh, and to anybody participating in any moot, I think it's equally important to read those judgments, whatever you're quoting in your footnotes. I think it's more important than before. I think in today's day and age, because even at my time when I would go and there would be lengthy footnotes, especially international moots, and judges will say, "Have you read these judgments?" The first thing that they ask you, and if you say yes, and then they'll ask you, "Okay, tell me which para, which page, is it comparable to any other thing?" And if you haven't read it, you're caught in the wrong foot. So I think you always have to realize while preparing, you have to be very sincere with your approach. There is always a word limit and page limit, I think, in memorials. So be very crisp with your research, with your judgments. See what are the relevant judgments. You can, I think, always cite extra judgments if the need be during the moot court, seeking the permission of the organizers or the judge. But research is the topmost. But the research will help you. If the issues are not already framed for you by the organizers, then it helps you in framing different propositions and different issues and address them accordingly.
So definitely agree with Mr. Jayant. And just to add, having been on the organizer side of moot court competition, I think one thing that maybe students don't give too much importance to is the citation style of footnotes. I think sometimes, depending on the mood, depending on the moot court competition, a lot of penalty is attracted because of the citation style of footnotes. So one should definitely pay attention to that. And I think generally the memorial document should at least at the very basic level be free of punctuation, grammatical, these kind of typographical, these kind of errors. I mean, it also goes on to say that when I was in law school, one very common question we used to have for our seniors was that what do we do when in the oral rounds a judge asks a question and we don't know the answer to, um, or if they point at something from the memorial and they ask something specifically about it. So although now I find this not very useful, but I mean at that time the answer we used to get was that you just say that this was a typographical error. But I think that's not the case. You don't say that. I don't think that's a very good way of addressing it. Uh, you should not have any typographical errors in your memorials, and you should definitely not take that as an excuse for your oral rounds. Yeah, that's all from my side.
Thank you, ma'am.
Adding to what Jayant sir and Garima ma'am said, uh, I believe that the memorial should be well structured, as in all whatever you want to say should be divided into sub issues and sub issues. Obviously, it should not be overdone, but it portrays that you have a clear idea of your problem and your arguments. And even if a person just has a glance on your issues, sub issues, and sub issues, the person has a rough idea what you want to portray and what you want the other person to be convinced about. And secondly, as Jayant sir already said, that the citations should be genuine and should be well read. The content in specific should also be very crisp, and it should not be repetitive or should not beat around the bush. That's all.
Okay, I have few points to add. Uh, there might be a chance that may overlap, but I think your memo writing style should be uniform. Now, what happens? There's three-member team. One member has drafted first issue, second member has drafted second issue, and third member has drafted third issue. Now, as a memorial judge, you will get to know different style of writing while evaluating the memos. Therefore, it becomes essential that it should be uniform. The style should be uniform. How you can do that? There are two ways which are suggested. One is IRAC and the other is CRAC. Of course, there are others also, but these are the populars which I've heard. So, one, the IRAC is first you talk about what is the issue, then you talk about the law, that is rule, and A stands for the application wherein you pull the judgments, and then finally your conclusion, right? And for CRAC, it's you start with the conclusion, what you have to prove to the tribunal or the court, then you tell the law, then your application, putting your facts, and then finally your conclusion. So by doing this exercise, you will make the writing style of the memorial in a uniform way. This is what I have seen in lot of uh, a lot of international teams doing, uh, and therefore it is suggested that you should follow. Also, I would suggest that there should be no over authority, because what happens, especially Indian teams have this habit of putting extra judgments and putting extra authorities on each citation. It might look good, however, the speakers are at a big problem when the judges ask each and every authority. So, if you are in a position to read each and every judgment which you have cited, you may do so. However, if you are not in a position to do that, kindly restrict yourself to limited authorities. Also, study the past winning memorials for each moot court competition before starting to write that memorial. Of course, sticking to citation style is very, very important. I think that's all I have to say. Thank you.
Thank you very much. So, uh, that the next question that is coming up for the panel is that how the construction of arguments should be done. Like, what are the points that should be avoided, and what are the points that should must be taken care of?
I think I'll just take this question. I think as a oralist or as a speaker in a moot, you must be prepared with all the issues at the back of your mind. It should be like even if somebody wakes you up in the sleep, you should know, what to argue and how to argue. And I had a very steep learning curve, and I think I was in my fourth year, and I'd gone for this Commonwealth moot back then in Nalsa. And fortunately, I got a very good team of tough judges. And the moment I started, I said, "May it please this honorable court, may I start with the issue, etc., etc." The judges, they know the best. They said, "Look, we don't want to listen to issue one. Come to issue two or issue three first," and that just upset my whole arrangement. But somehow I got over this obstacle, and then I think we eventually, qualified the moot also. But then in second round, when the same one of the judges was common, and I was already prepared to jumble up my issues and argue. So I think as a mooter, please don't have this thing of have a rote memory thing. जहाँ रट्टा मारते हैं वो नहीं होना चाहिए. Be thorough with your moot proposition. Be thorough with your issues at hand. Be ready that the judge can ask you anything from any point in time, and whatever issue may come up, just to upset you and see whether you're actually putting your real effort in this, or have you just memorized it and trying to regurgitate. So I think that's very important for any speaker. Be thorough. If you have four issues, know them by heart. The judge may ask you to pick issue four first or three first. There may be interlapping issues, so always be ready. And I think that there's a lot of hard work which goes into it. So don't skip hard work, because moot at the end of the day are all about the impression that you carry, not just to judges, but also when you get back to your law school. If you have won a decent moot, if you have won a prize, it shows you in a better light.
Alok sir, would you like to add on something?
Yeah. So, Madhur, just a suggestion. Whenever you ask the question, just name the speaker so that there's no pause, or just name the speaker, whoever you want to address it to, or whoever you want to start with. Okay, so construction of arguments, in my opinion, would so as rightly said by Jayant sir, you should be thorough with all your arguments and whatever authorities you are relying upon. However, coming to structuring or construction of arguments, I would say while framing your speech or while framing your argument or your structure, you should anticipate the question of the judges. So that, let's say, the judge asks you a question, you can move to the next sub issue, or you have to structure it around. Let's say some judge asks you a question and you say that precisely brings me to the second leg of my argument. So how you can anticipate the question of the judge? You can do so by understanding the case of the opposite party, because mostly the questions would revolve around, apart from the fact that what is the authority and what is the facts of the case. If they'll ask you question on merits, they'll put up the case of the opposite party. So anticipate what is the case of the opposite party, because you'll be preparing the memo from both the sides. So you'll be knowing that what is the case of the opposite side. So put that in your structure. It would help you while answering the question put forth by the judges. Also, structure your arguments in such a way, uh, as I said, you have to lay down or tell your story of your client in a very I would say in a very good way, uh, which helps the tribunal to understand your case. Therefore, apart from telling the law, there should not be over reliance on law. You should also put certain factual arguments while framing your speech. I think that's all I have to say with regard to this question. Thank you.
Garima ma'am, would you like to add something to this?
Yeah, so I think I will add, which although I think it's not enough how much we emphasize on it, that the structure of our arguments, especially in the oral rounds, has to be based on the time that we have. So a lot of times I've experienced, like when I'm judging a moot court competition, that only last 2 minutes are left, and the bench tells the person who's speaking that, counsel, let's just you only have 2 minutes left, let's hear your last argument on this. And then the counsel will start from the beginning of his last argument and even address the formalities. My suggestion is, or how in fact it should be done, is that you structure your speech according to the time left. So you know that you have less time, so you skip the formalities and you jump directly to the main content of your argument. You address the strength of your argument, you point out to the relevant facts, and you basically portray your case in within that limited time. So you don't it is not necessary that you have, I mean, we all understand that everyone prepares a speech and they have all practiced it and they all want to say it with full glory, but it is very important for a speaker to understand the importance of time management, and to understand the importance of adapting to the time left, or adapting to the situation, or how the proceeding is going in the actual oral round. So that's all from my side. Thank you, Madhu.
Thank you, ma'am. Anything you would like to say, Palak ma'am?
I would just like to add one more point, as I totally agree with Garima ma'am, that the oral speech of a particular team should not be the replica of their arguments as they've stated in the memorial. In the oral rounds, you just have to establish your point as quick as possible. So that due to the paucity of time that is provided, only the most important points should be laid out in front of the judge so that he or she is convinced and answer the questions with tacity, and then move on to your next argument, so that you have equivalent time for every of your argument, and not just and you do not waste a major time in explaining one thing and then summarizing your main arguments in a minute or so. That's all. Thank you, Madhur.
Thank you. The next question is from Jayant sir. That is how to respond to the question of judges.
Uh, we have lost Madhur, it seems.
I think some sort of, I think he's reconnecting.
And
Sorry, sir.
welcome back.
Thank you, ma'am. So the question is for Jayant sir, that how to respond to the question of judges.
You must know your stuff inside out. I think don't try to take them for a ride. For example, if Garima ma'am and Alok sir are, let's say, judging the moot, I'm sure they will be really grilling you. I can guess, because they're young blood, and I had this experience 5 years ago. I was judging this Kachwaha FDI moot. I have been associated with them for 7-8 years now, and somebody from my law school who had just graduated was just grilling one of the participants, so much so that he made the lady cry. And the other participant on my right, who was my co-judge, he said, "Sir, can you please at least calm him down?" And I just said, "Look, you have to know when to stop questioning. It's an arbitration moot at the end of the day. It's not a criminal moot that life sentence punishment has to be argued, or conversion of hang punishment for a life sentence." And I think from next year, the organizers were very clear that please be courteous to the students. I think judges have a bounden duty to be courteous, and the participants should also know, all their issues. As I said before, at the back of their hand, they should know, what is going to be asked. Sometimes anticipate, as Alok also rightly pointed out, that it's all a guessing game. It's all about anticipating. If you already know the problem, you know the proposition, they're not going to go out of it too much. But sometimes they may check your general awareness or general knowledge to see if the participant is just about the problem, or do they have more merit. And I think if you shine through that basic subtle questioning, in that mood, I think you might get some extra marks during the process. I think he's finished.
Sorry for the
Yeah.
technical glitches.
So Madhur, I'm done with my answer. Maybe the next panelist can answer the rest.
Thank you, sir. Garima ma'am, you would like to add something?
I think the most important thing in answering to the judges is to first really understand what the question is and to address it to the point. And if you don't know the answer, then you try to answer it in whichever way you can, but then you understand that you have to sort of at some point move on. I mean, although there are certain judges who will keep at it, will keep pushing you to answer the same question, but at some point the skill of the person speaking is in being able to understand when they have to persuade the bench to move on, and to because otherwise there's no point. The bench, the judge gets an idea fairly early into the question if the person who's speaking knows the answer or not. So they still give you some time to give you the opportunity to answer it if you want to, if you can. But after a point, I think there's no point in beating around the bush, and it's just best to move on and to utilize whatever time is left in addressing the questions that you probably know a better answer to.
Thank you.
Uh,
Thank you.
I think I've realized with me, I've really placed a lot of importance in time management. Because I think that's what we really struggle with when we are actually there in the oral rounds. Everything is time bound, and there are questions. We have our speeches prepared, and then we just struggle with time. So even answering a question, we have to keep in mind the time.
Thank you, ma'am. Alok, sir, the next question is somewhat based on what Jayant sir quoted. That sometimes students face hot bench and sometimes they face like a cold bench of judges. Then how to tackle in both the situations?
Okay. So what I did to tackle this situation, I carried different structures because I never made a speech for my oral round. I carried always structure only with one